All right, Mr. Bennett, we have Mr. Jones here. Do you need a breakout session with him before we start?
I do not, Your Honor.
Okay. All right, we are on the record then in files 23-21615-FH, 23-21616-FH. And I apologize, I guess that's the only two. So People versus Maurice Leroy Jones. We are here today for a pretrial conference in this case, as well as a pretrial conference on an alleged violation of bond conditions. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the People.
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Jones today.
All right, and Mr. Bennett, where do we stand with Mr. Jones' cases today?
Your Honor, Ms. Arnold and I have been having some difficulty getting together to work out a plea agreement. I think at this time we probably should just set a final settlement conference and a trial date, I suppose. I think we've been going a while.
Judge, I would actually ask if we could set a pretrial in 1 week. I can make an offer to Mr. Bennett. I had a death in the family last week and I was out every day except one. So I meant to get him an offer and I just haven't done it yet. So I think one more pretrial in a week or so would be appropriate. And at that point, if we can't resolve it, to set it for trial.
I'm available next Wednesday, Your Honor.
Okay, I've got a pretty full docket next Wednesday, and then I'm not here the following Wednesday, so I'm going to set it for March 27th.
That works for me, Your Honor.
That's fine.
So March 27th at 8:15, and I would agree at that point that if we don't have a resolution that I would set it for trial at that time. I think we're right around or over 100 days past buying over at this point. So
right, I would agree, Judge. I meant to have an offer to Mr. Bennett, but circumstances happened and I just wasn't able to.
yeah, I understand. Let's see, Mr. Bennett, then would you do a stip in order for that adjournment?
Yes, Your Honor.
And Mr. Jones, so your next date is March 27th at 8:15 a.m. You'll log in with all the same Zoom information that you used to log in today.
Okay.
All right, you're all set then. You can go ahead and log out.
Your Honor.
Thanks, Judge.
All right, good morning, the gentleman at the MDOC facility. Let's see, I've got two people here. So the person that's in the room with the gray walls, can you tell me your name, please? Okay. And the other gentleman, you are Mr. Fold?
I'm on Mr. Bradley.
Okay, the gentleman in the room with the white walls, you're Mr. Folds?
Yes, sir.
Okay, Mr. Folds, I'm gonna put you back in the breakout room for or back in the waiting room for just a moment, okay?
Now you talking about me?
Yes, sir, I'm gonna put you in the waiting room for about 5 minutes, all right?
Yes, sir.
Okay, Ms. Underwood, do you need a breakout session with Mr. Bradley?
Your Honor, I've spoken to Ms. Arnold. Unfortunately, Mr. Bradley, appears to have a new file that we're going to have to deal with, Your Honor. So we would ask for perhaps a 3-week adjournment to do that.
Ms. Arnold, do you have any objection to that?
No, I think that would be appropriate, Judge.
All right, so let's set it then for March 27th at 8:15. Ms. Underwood, would you do a stipulation in order for that adjournment?
I will do that with Ms. Arnold's permission, Your Honor.
Of course.
Mr.
Okay.
Bradley, I will be in touch. Thank you.
Thank you.
All right, and Ms. Arnold will need to have the prosecutor's office prepare a writ.
We will, Your Honor.
Okay. All right, thank you. Mr. Bradley, you can let the officers with you know that you're done with court.
All right, thank you.
Thank you.
Okay, Ms. Underwood, do you need a breakout session with Mr. Folds?
I do, Your Honor. Thank you.
Okay, the gentleman at the corrections facility in the state of Ohio, you are Mr. Powers?
Yes, sir.
Okay, 1 second. Your attorney is just getting moved into the meeting. All right. Okay, so Mr. Lynn, do you need a breakout session with Mr. Powers?
Yes, Your Honor. Thank you.
All right, 1 second. Could you call the jail for Amy Garza?
Yeah, this is Judge Olseger's courtroom, and we need Amy Garza, please. Thank you.
Okay, Mr. Bagley, I do have Ms. Kester here by Zoom. Are you going to need a breakout session with her?
I am not, Judge. Thank you. Thank you so much for asking.
Okay. All right, then. We are on the record in file 23-21366-FH, People versus Holly Sue Kester. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
Good morning, Your Honor. I apologize. I'm a little under the weather today, but Phoebe McClure on behalf of the people.
Your Honor, Patrick Bagley on behalf of Holly Kester, who is with us on Zoom, as we can see.
All right, and Mr. Bagley, where do we stand with Ms. Kester's case today?
Well, Judge, we've brought the motion in front of this court. The motion was denied by this honorable court, and the way I see it, Judge, we need some time for discovery and exchange of exhibits and witness lists and so forth, and then a trial date in the court's discretion.
Okay, how much time do you believe you need to do the discovery that you need to do?
Ms. McClure, what do you think?
Judge, I would, just knowing how long out some of these trials are going to be, and this one's going to be a little bit longer, I would just ask that we get a trial date now so that we're on the calendar.
Yeah.
And well, I mean, as far as I know, unless Mr. Bagley has a lot more discovery that I need to consider, he has everything that I have.
So that's what I was trying to gauge is when are we looking to set a trial date and how long, how many days of trial do you think?
I think the trial, realistically, we should probably, I mean, it's hard to say. The exam took 3 days, so maybe 5 to 6 days for a trial.
Yeah, I was going to say, Judge, a week and a half to 2 weeks.
Yeah, and I would be okay putting it out to maybe August or September.
Yeah, Judge, I've got a trial in the beginning of September, a big one. So I would ask to get pushed after that.
And then maybe have like one pretrial and a final pretrial in between.
That sounds good.
All right. So Sierra, do you have our scheduling book right now?
I can run down to Francis's office and grab it just a second, Judge.
All right, thanks.
Judge, did I hear that we were looking for 2 weeks starting in October?
Yeah, 2 weeks, and it sounds like the beginning of October from a time.
Okay. Would you like to go through Mondays as well?
Maybe one, but not 2 in a row.
Okay, so we could start on Tuesday, October 1st, do the end of that week, start Monday, October 7th through all of that week, and come back as needed.
So that'd be Tuesday, October 1st through Friday, October 4th. And then Monday, October 7th through the end of that week, the 11th.
Judge, is there any chance that we could push the start date back 1 week and start the week of October 7th? Possibly.
Yes, Judge, that works with your schedule.
So Ms. McClure, any issue with that?
No issue with that, no.
All right, so let's start Tuesday, October 8th, then through the 11th. And then the 14th through the 18th.
And Judge, would those all be 9 o'clock start times, except for Wednesdays would be 10:30?
Yeah, correct. So the Wednesdays will be 10:30 start time. Every other day will be 9 a.m.
Okay.
And so let's do a final pre-trial. Does September 25th work? At 8:15 a.m.
If that works for the defense.
That works, Judge. And then could we maybe have like a July pretrial too, just to touch base?
Yeah, how about July 17th at 8:15?
Okay, thank you. And if we need any motion dates or anything, we'll get them too.
Judge, you said July 17th for the
17th.
Okay, yeah, 7/17.
Okay. All right, so I will issue a scheduling date or scheduling order with all those dates in it, and we'll mail a copy to each of you.
Thank you, Your Honor.
All right. Anything else we need to address today?
Nothing from defense, Judge.
No, thank you.
All right, thank you then, Mr. Bagley. Ms. Kester, you can go ahead and log out.
Thank you, Your Honor.
Thank you.
Okay, Ms. Underwood, are you ready to proceed with Mr. Foltz?
Yes, thank you, Your Honor.
All right. We are on the record then in file 23-21481-FH, People versus Joshua Dwayne Foltz. Here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Rhonda Underwood on behalf of Mr. Foltz this morning, Your Honor.
Okay, Ms. Underwood, where do we stand with Mr. Foltz's case today?
At long last, we have received our criminal responsibility report, Your Honor. I'm reviewing that with Mr. Foltz. If we could have a pretrial the first part of April, Your Honor, we should know whether or not we're going to have an independent in this, or and probably who that will be by then, and whether or not that is the direction we're going to go, Your Honor.
Okay, Ms. McClure, anything we need to address from the people's standpoint?
Nothing to add, Judge.
All right, so first part of April. We do April 10th at 8:15 a.m.
And I will do the stipulation to adjourn with Ms. McClure's permission.
No objection.
All right, I just know somewhere along the line, we lost Mr. Folds. So given the fact that we've simply adjourned it for him to have an opportunity to speak with Ms. Underwood, I don't think that is a significant issue. So Ms. Underwood, yeah, if you would just do that stipulation in order, we will conduct another pretrial in April.
Thank you, Your Honor.
Okay, thank you. And then Mr. Linton, are you ready to proceed with Mr. Powers?
Yes, Your Honor.
Okay, we are on the record then in file 22-21173-FH, People versus David Eugene Powers. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with, we have a prosecutor covering the David Powers case.
I can cover it, Judge. First, I'm going to appear on behalf of the people.
All right, Mark Linton on behalf of the defendant.
All right, and Mr. Linton, where do we stand with Mr. Powers' case today?
Your Honor, so Mr. Bayonetto has extended an offer of pleading to fleeing, eluding, fourth degree misdemeanor and malicious destruction of property, $200 to $1,000 misdemeanor. What I'd be seeking is, due to a lack of memory and potential civil liabilities for a no contest plea, as well as a Cobb's evaluation. Mr. Powers has been in prison in Ohio, and he was eligible for release on October 5th of 2023. But because of the outstanding warrant and then the pendency of this case, he has not been able to be released. So I guess I'd be seeking if the court might entertain a time served potentially.
Have you run any guidelines? Do you know where this would come in?
I don't have his guidelines run, Your Honor. I'm sorry.
I'm not really in a position to give a Cobb's evaluation without some more information about the situation. So I'm not willing to do that at this point. If you want to adjourn this for a week and set up a time where we can discuss this, I'd be happy to do that. But
okay,
you know, I'd just be throwing darts blindfolded if I tried to do an evaluation right now.
I understand, Your Honor. So if we could put it over a week and we can get you that information.
Right, so let's set it for a week from today. That's March 13th. At 8:15 a.m.
Okay. Very good. Thank you.
And Mr. Lynn, would you do a stipulation in order for that adjournment, please?
Yes, Your Honor.
All right, and then we'll need a writ or need to make some kind of arrangements with Mr. Powers' facility so that he can be available next week as well.
Okay.
I will have our secretaries do the Zoom writ, Judge. Usually want a little bit more time than just 1 week, but I'll try to make sure that that is done.
I appreciate that.
And Mr. Linton, you can sign that stip in order with my permission.
Okay. Thank you.
Thank you, sir.
All right, Mr. Powers, you can let the officer that's with you know that you are done with court for today.
Okay, thank you, sir.
Okay, Mr. Glazer, I just contacted jail about Darren Johnson, and Ms. Garza, your attorney was logged in and has moved over to Judge Anselon's courtroom, so I'll proceed with your case as soon as we have him back. Any one case you?
Morning, Your Honor. I have Grant Doll, and I just need a adjournment for another pretrial. Mr. Sneed gave us an offer yesterday, and my client would just like a few days to consider that.
Grant Dole. Okay, how about March 27th?
That would be fine, Your Honor. Thank you.
Can you do a stipulation in order for that?
Yes, we can. That also be at 8:15?
Yes.
Thank you.
I'm sorry, Ms. Wagner, did you want to say something about the Dole case?
No, Judge, the adjournment is fine. And I just wanted to let you know, Ms. McClure has logged off. She's struggling with her voice this morning, so I'm going to cover the rest of the cases that she would have had.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Okay, thank you, Ms. Hennigan. All right, good morning, Mr. Mawad. You're here for the Samuelson case?
Yes, Your Honor.
Okay, and sir, are you Timothy Samuelson?
Yes.
Okay, Mr. Mawad, Mr. Samuelson is here in the courtroom. Do you need a breakout session with him?
No, Your Honor. I talked to the APA on the case this morning, and he is I think there's Chris, and he needs a couple more weeks just to see what kind of plea offer there's going to be. And
Okay.
Mr. Samuelson and I know that also. We've been discussing that.
All right, Mr. Samuelson, you want to come forward and just sit at this table here, please? This is file 23-21614-FH, People versus Timothy Preston Samuelson. We're here today for a pretrial conference in this case and proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Fleming.
So it appeared on behalf of the people.
Elias Muad appearing on behalf of Mr. Samuelson.
All right, and we were just having a discussion, Mr. Mawad. It sounds like you're just requesting an adjournment today. Is that correct?
Yes, Your Honor. Chris, what do you think you need? 2 weeks more, a little bit more? What do you need?
I think 2 weeks will be perfect.
Okay, I am out the 20th, which would be 2 weeks. So let's go with the 27th at 8:15, if that works.
Yeah, that
works
March
people.
27th. It works, Judge.
So March 27th at 8:15 a.m. Mr. Samuelson, you're welcome to come back and be here in person like you are today, or if you prefer to do it by video conference, the bailiff will give you our Zoom information.
Thank you, Your Honor.
Okay, so you're all set for today. And Mr. Mawad, would you do a stipulation in order?
I will, Judge. And Chris, can I sign your name to the
Absolutely.
stipulated order?
Of course, thanks,
beautiful.
Steve.
Thank you, everybody. Thank you.
Thank you, then, Mr. Samuelson, you're all set. All right, the gentleman at the jail, are you Mr. Johnson?
Yes.
Okay, Mr. Glazer, do you need a breakout session with Mr. Johnson?
Yes, I do, Your Honor.
Okay, one second. Yeah.
Yep.
Good morning, Mr. Shelton. Are you able to hear me?
Yes, sir.
Okay. So we are on the record in file 19-19673-FH, People versus Justin Matthew Shelton. We're here today for an arraignment on a summons for probation violation. We are proceeding today by video conference, and sir, for the record, you are Justin Matthew Shelton. Is that correct?
Yes, sir. Yep.
All right, Mr. Shelton, I presume you received a copy of the summons since you're here today.
A copy of the summons?
Correct.
No, I haven't.
Well, you would have received the copy with the violations we spoke about and with the court date on today. That's the summons.
Oh yeah, the one that you emailed me, I believe.
Yes.
Okay,
Yes.
so you did get a document that listed what all the alleged violations are. Is that right?
Yes.
Okay.
Wait. I'm sorry. So I violated my probation. Is that was
there?
Not
There's
sure
there's an allegation that you violated your probation by not making payments toward your costs and fees in this case. Do you understand that?
Yes, sir.
Okay. So you had originally pled guilty in this case to one count, it looks like, of uttering and publishing. Do you understand that?
Yeah. Yep. Yes, sir.
And you understand that the maximum possible penalty for an uttering and publishing conviction is up to 14 years in prison?
Yep. Yes, sir.
Okay. You are entitled to have an attorney represent you today and at any other proceedings that we might have. If you can't afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Do you want to be represented by an attorney today?
I guess not.
Okay. And so I did get a communication from Mr. Moore that indicated that you've already made a significant payment toward what you owe, and that Mr. Moore was in agreement with just setting this out for another date to give you some time to make the remaining payment. Is that accurate, Mr. Moore?
That's accurate, Your Honor.
Okay. Is that also what you'd like to do, Mr. Shelton?
Yeah. Yes, sir.
Okay. So what I'm going to do is enter a not guilty plea for Mr. Shelton, and we will set this for another hearing on April 24th at 8:15 a.m. Mr. Shelton, you'll log back in with all the same Zoom information that you used today, and we'll see where things stand with the payments at that point.
Okay. Thank you.
All right. So you're all set then. You can go ahead and log out.
Thank you, Your Honor.
Thank
you. Okay, Mr. Glazer, we'll have Mr. Powers back here in just a moment. I just closed the Zoom. Okay, we are on the record in file 24-21743-FC, People versus Darren William Johnson. We are here today for a arraignment in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wagner.
Amanda Wagner for the People.
John Glazer on behalf of Mr. Johnson.
All right, and you, sir, are Darren William Johnson?
Yes, sir.
All right, and Mr. Glazer, does Mr. Johnson wish to have the information read?
No, Your Honor, we'd waive the reading of the information, acknowledge the receipt of that. At this time, my client's gonna enter a plea of not guilty, Your Honor. And I'd ask for a pretrial date 45 to 60 days away. There's a issue that I'm probably gonna be filing a motion to suppress on, and I need some time to look up the law in regards to that.
All right, Ms. Wagner, anything we need to address from the people's side then?
No, Your Honor. I mean, I think 45 to 60 days seems like a lengthy adjournment. I don't know that that much time is necessary, but no problem adjourning that out 30 days at least.
She can come do the research for me if she wants. It's gonna take a while.
All right. All right, let's go with May 1st at 8:15 a.m.
That'll work, Your Honor. And if I get the motion drafted, I may change that date and just get a motion date if I can.
That'd be fine. And Mr. Glazer, can your office do the stipulation order for that adjournment?
Yeah, we can do that, Your Honor.
All right, Mr. Powers, you can let the officer that's with you know that you are done with court for today.
Mr. Johnson, Your Honor.
I apologize, Mr. Johnson.
Okay, thank you.
All right, thank you.
All right, thank you, Your Honor. I think that's all I have with you this morning.
Yep, okay, thanks, Mr. Glazer.
All right, thank you.
Jot down the date on Joshua Folds, what his next date was.
April 10th at 8:15.
Okay, Mr. Folds, I apologize. I did not realize that you had dropped out of the meeting somehow. The hearing for your case was adjourned to April 10th at 8:15.
Okay.
So you can let the officer that's with you know that you're done with court, and we'll see you back on that date.
April when, sir?
April 10th.
Okay, I got one more question for you, Judge. I was under the impression that that they was telling me that I gotta come to court to see the I had to go to court for my criminal intentions, right? Criminal intentions. What was the findings? Like I'm trying to figure out like what was the
Okay, so that's why we adjourned your hearing today, was because your attorney just received that report and she wanted to discuss it with you.
Okay.
So she's gonna set up a meeting to go over that with you.
Okay, sir. And my last question is, do you think that it's a criminal intent?
All right, so Mr. Folds, I'm gonna stop you there, Mr. Folds, just because I can't give you legal advice or my opinion on things. You're gonna have to discuss that with your attorney.
All right, because only thing my attorney keep asking me is I want to take a copy.
Okay, I don't want you, I don't want you to discuss with me what your attorney has discussed with you, because that's confidential information. So you just wait until Ms. Underwood sets up a meeting to review that report with you.
Okay, sir. Just from a judge point of view, though.
Okay, I can't tell you, sir. I can't do that. We can't have a discussion about that. So I'm going to remove you from the meeting now. You can let the officers that are with you know that you're done with court for today.
Justin Johnson.
Okay, Ms. Kneisel, it's my understanding that you just want to dismiss this show cause for Justin Johnson.
That is correct, Your Honor.
Good morning, sir. You are Justin Johnson.
Yes, Your Honor.
Do you have this one?
I do not have this.
Sorry, this was a pickup this one. All right, give us one moment here, Mr. Johnson. We need to add your case to our computer system. Okay, this is case 13-39048-DS, Tricia Lynn Bryan versus Justin Allen Johnson. We are here today for arraignment on a bench warrant for alleged non-payment of child support. And sir, you are Justin Allen Johnson?
Yes, Your Honor.
All right, I have received some communication from the friend of the court office that since this bench warrant was issued, you have been making consistent payments and they would like to dismiss the alleged contempt. And so I'm going to dismiss that show cause as well as dismiss the contempt for failure to appear. We'll get that paperwork processed and we'll get you released as quickly as we can.
Thank you. I appreciate it, Your Honor.
All right, so you're all set. You can let the officers with you know that you're done with court for today.
All right, thank you. You have a good day.
Thank you, you too.
Thank you, Your Honor.
Okay, thank you. Ma'am, do you have a case or are you waiting for someone to be called?
I'm waiting for Harlan Bussing.
Oh, okay. You had
The date?
Yeah.
March 15th, 8:15.
Okay, his attorney, Mr. Daly, asked us to adjourn that case, so it's gonna be next week on the 15th at 8:15.
Okay. Thank you. Next Wednesday, right?
Correct, 1 week from today.
Okay, thank you.
Hello, this is Judge Olsek. I'm fine. How are you doing today? Oh, no, she's out today. Yeah, her attorney logged out of my courtroom and is over in cases in Judge Anselm's courtroom, and he was here, and then right after I called for Ms. Garza, he jumped over to Judge Anselm's courtroom, so I'm waiting for him to come back. If you need the room, you can take her out because I don't know when he's going to be back. Oh, I'm sorry, he just now logged back in. Okay, thank you very much. Bye. Ms. Garza, are you there? Okay, Mr. Murphy, do you need a breakout session with Ms. Garza?
Please, Your Honor.
All right, 1 second. All right, we have Mr. Murphy and Ms. Garza back from the breakout session, so we are on record in file 23-21452-FH People versus Amy Monique Garza. We are here today for pre-trial in this case, as well as a hearing on alleged contempt of court for violating bond conditions. Let's see, first let me ask the attorneys to place their appearance on the record, beginning with Ms. Wagner.
Thank you, Judge. For some reason, my camera won't turn on, but I'm here. Amanda Wagner for the people.
Matthew Murphy, appearing back for Ms. Garza.
And Mr. Murphy, where do we stand with Ms. Garza's case today?
Your Honor, first of all, I had down, and I may be mistaken on this, is why I'm going to ask Ms. Wagner to correct me if I'm wrong. I had down previously that Ms. Garza was offered a retail fraud second offense, 1-year misdemeanor on this. If I'm incorrect, or if that's not the case anymore, I just ask Ms. Wagner to correct me on that, if she knows.
I am checking right now, Mr. Murphy.
Thank you. Also, Your Honor, I didn't know, in regards to the contempt of court, I would think I was misinformed. I thought it was for missing a court date, but it's for violating bond conditions. If Your Honor could inform me on that, I just would ask for that.
Correct. She was, well, she's got actually two. So she had a bench warrant out for registering a 0.148 blood alcohol level. And then at the time that she was arrested on the bench warrant, she also had alcohol in her system. I don't know, it was 0.20 something. Where did that go? At the time that she was arrested.
Okay.
0.209, she blew a blood alcohol content at the time she was arrested, according to the police report.
All right, Your Honor, could I just have a brief breakout again, Ms. Garza? Because again, I didn't realize that was the allegation on those. I didn't know if she wanted to plead to those today or not.
All right.
Based, you know.
1 second. We have Mr. Murphy and Ms. Garza back again. So Ms. Wagner, were you able to determine what the offer to Ms. Garza was?
Yes, Your Honor. Thank you. Retail fraud second is fine.
Your Honor, at this time, Ms. Garza, first of all, she did want to accept responsibility and inform Your Honor that she is going to plead guilty to the contempt for violating bond conditions. And with the offer being a retail fraud second, Ms. Garza does wish to enter a plea of guilty to a retail fraud second. And then I just ask that I be able to address bond after the entrance of the plea.
Okay, so it's retail fraud second degree or second offense?
I think it would be second offense. Well, I guess second. Well, I guess let me see. I don't know.
So right now, charge on the information right now is retail fraud first degree with a second or subsequent offense notice.
We're talking about retail fraud second, a 1-year misdemeanor, correct, Ms. Wagner?
Yes, that's correct.
All right, so I'm going to need an amended information for that.
I'll get that filed, Your Honor, right away.
All right, Ms. Garza, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Amy Monique Garza?
Yes.
You can put your hand down if you like. Have you heard the statement of your attorney and the prosecuting attorney? Is it your intention to plead guilty today to retail fraud second degree?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail or a fine of not more than $2,000 or 3 times the value of what was taken, whichever is greater?
Yes.
Are you satisfied with Mr. Murphy and the advice he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the courts. Is that correct, Ms. Wagner?
Yes, Your Honor.
Sir Murphy?
That's correct, Your Honor.
Is that also your understanding, Ms. Garza?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, and you or your lawyer could ask those. You have the right to be present at trial and have the witnesses against you appear at your trial, and you or your lawyer could ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Garza, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
Yes.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about May 19, 2023 in the city of Adrian, County of Illinois, that you did commit the offense of retail fraud second degree? If you answered, I was not able to hear you.
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Garza to plead guilty?
No, Your Honor.
Ms. Garza, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor. Thank you. Ms. Garza, were you in the city of Adrian, County of Lenawee, state of Michigan on May 19th of 2023?
Yes.
You were at the Meyer store on that day, correct?
Yes.
Okay, and while you're at that store, you took multiple items and placed them in a shopping cart, multiple clothing items that were offered for sale, correct?
Yes.
And you took that shopping cart past the point of sales, past the cash register, is that correct?
Yes.
Okay, and then the loss prevention individual stopped you at the exit and they recovered all those items, correct?
Right.
But is your intention to leave the store without paying for those items, correct?
Right.
Okay, and would you agree that the value of those items was between $200 but less than $1,000?
Yeah.
Your Honor, I believe we satisfied the factual basis.
All right, Ms. Wagner, are the people satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with MTR 6.302 B, C, and D, Ms. Wagner?
Yes.
Mr. Murphy?
Yes, Your Honor.
I will accept a plea. It's been given understandably, voluntarily, and accurately. Ms. Garza has had full knowledge of her rights. She's had competent counsel. Court has not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone. Give them. I will refer this matter to the district court probation office for a pre-sentence investigation interview and set sentencing for looks like April 12th at 8:15 a.m.
Yes, Your Honor.
So all right, Mr. Murphy, I think you indicated that she also wanted to plead guilty on the, there's 2 contempts at this point.
Yes, Your Honor.
All right. Ms. Garza, you were previously arraigned on a bench warrant for violating bond conditions as well as a complaint for violating bond conditions relative to your use of alcohol. Do you remember that?
Yes.
Do you understand that you have a right to contest those contempt of court charges and to have trials on those?
Yes.
Do you understand that the maximum possible penalty for a contempt of court is up to 93 days in jail and or $7,500 in fines?
Yes.
Do you understand that if we had a trial, that throughout that trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yeah.
You'd also, again, have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses you might have for your defense to appear at your trial. Do you understand all of that?
Yes.
Again, you're not required to testify, and no one can say anything about you not testifying or hold that against you in any way. But on the other hand, you also would have the right to testify if you wanted to testify. Do you understand that?
Yeah.
How would you like to plead to the charge that you violated your bond conditions on August 9, 2023 by having a 0.148 blood alcohol content?
Guilty.
And how do you want to plead to the charge that on or about February 29, 2024, that you violated your bond conditions by having a 0.209 blood alcohol content?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Was anything promised to you in order to get you to plead guilty?
No.
Were you threatened in any way in order to get you to plead guilty?
No.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
So you have been under bond conditions that say that you're not supposed to use any alcohol or consume any alcohol. Is that right?
Yes.
And you were doing some testing as a result of your bond conditions. Is that right also?
Yes.
And back on August 9 of 2023, did you do a blood alcohol test at the sheriff's department at that kiosk?
Yes.
And did that test show a 0.148% blood alcohol content?
Yes.
And you had some interaction with the police back on February 29th, 2024. Is that right?
Yes.
And had you consumed some alcohol at that time?
Yes.
And it looked like, according to the police report, that you consumed at least a drink right in the presence of officers. Is that right?
Yes.
And when they did a breath test on you, that indicated that you had a 0.209 blood alcohol content. Is that correct?
Yes.
All right, I'll accept those pleas. They've been given understandably, voluntarily, and accurately. Ms. Garza has had full knowledge of her rights. She's had competent counsel. Before the court passes sentence, Mr. Murphy, is there anything you'd like to say on behalf of Ms. Garza?
Yes, Your Honor. In regards to Ms. Garza, I think the obvious issue here that's driven this behavior is obvious from her acceptance of the her admittance of her guilt here, is the fact that she has an issue with alcohol. And I think that when the court considers a sentence on the contempts and considers her bond, what I ask court to consider here is that Ms. Garza needs assistance with dealing with that. Obviously, keeping a person in jail, it might achieve the desired effect of sobriety in the immediate. They might refrain from consuming alcohol while they're in custody. Of course, we all know that sometimes substances are produced in jail and in custody. But again, I understand that is the immediate solution for a person who has a problem with alcohol would be to keep them in jail. But I think that in this situation, Ms. Garza, she's a young woman. She is asking the court to have mercy on her and to consider that she needs assistance in dealing with this issue. So I'd ask the court to consider not just incarceration. I'd ask the court to consider release. Ultimately, I was hoping for probation on the retail fraud. So I was hoping for either credit for time served and a probationary period to be served for the contempts. And I think that if the court was to look at that as an opportunity to give her the tool that she needs, maybe have outpatient counseling ordered to begin with, or inpatient counseling ordered. But again, I'd ask the court to consider not just incarceration in regards to Ms. Garza. Thank you.
All right, Ms. Garza, is there anything else you'd like to say on your own behalf before the court passes sentence with respect to the contempts?
Sure.
So I wasn't able to hear you.
Oh, sir.
All right. Okay, I do recognize that addiction to alcohol is an issue that requires treatment. I also, find myself often in these positions where person is under a court order that they disobeyed, in this case, 2 times. And the most recent time, excuse me, fairly significantly, 0.209 is a really high blood alcohol content. In addition to that, was consuming the alcohol right in the presence of officers as she was being arrested. And so I think that, in addition to trying to get people help, the court has to act to punish contempt as a deterrent factor, which I think is where we find ourselves today in some kind of hybrid between those two. We're balancing between those 2 issues. So I think given the behavior here that a jail sentence is appropriate. And so it's going to be the sentence of the court that Ms. Garza serve 45 days in the Lenawee County Jail with credit for 6 days served on both of the contempts. As I've indicated, I think that, ultimately that treatment is what is required here. And so I will provide that she can be released early to a residential inpatient facility if she can make, or if arrangements can be made in order to do that. So that will be the sense of the court on the contempt, and we will see Ms. Garza back on April 12th for sentencing on the underlying charge.
Yes, Your Honor. Thank you.
Thank you. Ms. Garza, you can let the officer that's with you know that you are done with court for today.
Thank you.
Thank you, Ms. Garza.
Yeah.
Mr. Murphy, we also had Ms. Marquis on the docket today, and she is not. You're all set, Ms. Garza. You can go. We had Ms. Marquis on the docket, and she is not logged in and not present here in the courtroom. Do you know anything about her today?
Your Honor, I had emailed Ms. McClure and your staff. I believe it was Ms. Clark that I emailed about Ms. Marquis. She is on diversion, and so I'd asked. I thought Ms. McClure had no objection. We're just trying to figure out what the next date would be to adjourn to. I didn't see a point in ultimately being on the record and doing a stipend order ultimately. So I had actually informed Ms. Marquis just yesterday. I told her not to appear because she was trying to get she was having a scheduling conflict. I can call her if Your Honor wants and see if she can appear.
That's fine. I wasn't aware that you had contacted the office. Did you get a new date then?
No, because I emailed yesterday saying that I was asking for maybe 60 days because as far as I understand it, and again, Ms. McClure had emailed that she was on track. So I'd assume that if she wasn't, then Ms. McClure would have objected. So I figured 60 days would be sufficient to make sure she's continuing to make the payments and on track to complete it.
Judge, if it helps, we last had contact with Ms. Marquis through the diversion program at the end of February. She's not exactly on track with her payments, but she did let us know that she had been participating in some court-ordered mental health treatment in Saginaw. She's completed that and is back and advised that she would start payments again in March. So with that, we wouldn't object to the adjournment.
Okay. So 60 days, looks like let's do May 15th.
Yes, Your Honor. Thank you.
And Mr. Murphy, would you do a stipend order?
Yes, Your Honor.
Judge, I'm going to log out and back in real quick to see if that resolves my video issue.
Okay, thank you.
Thank you.
All right. And Your Honor, that's all that I had scheduled. If you need me, please call the office. But everyone have a good day. Thank you.
Okay. Thank you, Mr. Murphy.
Judge, is it 6 days credit for time served on?
Yep, 6 days. Okay, we're just waiting for Rhonda to get logged back in. I think Mr. Relindi is the last one we have.
Okay, thank you, Judge. Sorry about that. I had to restart my whole computer.
No problem. Alfred. Wait for.